Right, and welcome back to Morning Express. It is time now for us to get into Political Point, and we want to start off with a story that just gives us a background of what we'd like to discuss. And Samburu Governor Moses Lenolkulal has now moved to court to appeal a challenge ruling given by Justice Mombasa Road, blocking him from accessing his office until graft case lodged against him is determined. The appeal comes a day after Ethics and Anti-Corruption Commission insisted that the ruling must be implemented to the letter and that it should also apply to besieged Kiambu Governor Ferdinand Waititu, who is expected to know his fate of his bail terms this morning. Our senior political affairs reporter Chris Thyro gives us a bit more insight.
As Kiambu Governor Ferdinand Waititu awaits to know his fate on Tuesday morning on the terms that will be set on his bail, the question as to whether governors who have been arraigned in court over corruption-related charges should be blocked from their offices continue to dominate the political and legal discourse. Given that the Samburu Governor Moses Lenolkulal was blocked from accessing his office until his corruption case is determined following a ruling by Justice Mombasa Road, Lenolkulal, through his lawyers, rushed to court Monday morning, challenging the ruling through an application filed under certificate of urgency at the Court of Appeal. And the DPP is seeking the same fate facing the Samburu governor to befall Kiambu Governor Ferdinand Waititu, an application that his lawyers term as unconstitutional.
As we move into the province of the presumption of guilt before trial, then this is an abrogation of Article 49 1H, the whole of Article 49 and 50, and the right to fair trial.
We understand the law very clearly on that matter and how that is to be done. And it is not our intention anyway to remove him from office.
While those who are against blocking besieged governors from accessing their offices argue that the courts cannot purport to remove a governor from office, those in support of the ruling maintain that the moment one takes a plea in court, their integrity and accountability status remain dented.
This court cannot turn itself into an electorate and end the term of an elected governor prematurely because it's facing terms.
If you are charged with a corruption-related offense, how is it that you can return in that office and continue with your business as usual when that office requires public trust? Public trust is destroyed the moment you are charged, you are accused of theft of public resources that are under your care as a governor.
Some of the counties that are on the DPP and EACC radar include Tharaka Nithi, Garissa, Siaya, Turkana, Marsabit, Kitui, Murang'a, Homa Bay, Migori, Wajir, Nairobi, Machakos and Nandi counties.
You can't be accusing the judiciary of not supporting their own graft. But when the judiciary reads the Constitution purposively, tries to breathe life to the Constitution, and says, listen, the Constitution requires people whose probity, uprightness, honesty, integrity are not questionable. Is that not what the Constitution is required?
According to Article 181 of the Constitution, on the removal of a county governor, one can only be hounded out of office if there is gross violation of the Constitution or any other law, where there are serious reasons for believing that the county governor has committed a crime under national or international law, abuse of office, or gross misconduct, or physical or mental incapacity to perform the functions of the office of the county governor.
You know, the governor nominates the county public service board, who employs all the staff there. If he sits there and the witnesses are part of his staff, of course he's going to intimidate them. He will intimidate them.
If the Court of Appeal upholds the decision by Justice Mombasa Road, then governors who have been taken to court will have no option but to either operate from their private offices, hotels, or even at home. But this does not mean that there is any vacuum that has been created, since they remain the substantive governors elected legally. Chris Thyro, KTN News in Nairobi.
All right, and that debate continues, and would like to now move and come to the panel that I have this morning. We're joined by Joy Brenda Mdivo, who is a lawyer. We have Honorable Jeremiah Kioni, who's Member of Parliament for Daragwa, but also a lawyer, and Honorable Anthony Oloch, Member of Parliament, Mathare, also a lawyer. It looks like, Joy Brenda, you should also be in politics at this stage. It looks like
it is time.
we have quite a number of lawyers who've got into politics. But anyway, away from that, maybe just to get clarity on that particular ruling by Justice Mumbi Ngugi, and maybe I'll start with you, Joy Brenda, on whether this was specifically for Governor Lenolkulal, or was it one that was generally given if a governor and maybe any elected member is found or charged in court, then should they be expected to step aside?
The principle of stare decisis is such that once a decision is made by a superior court, all the lower courts are bound by that decision and they must rule in that direction. When you have a higher court, which is now where the governor has gone, they can make the decision to look at the decision afresh. Now, there was the 2012-2013 decision for the ICC. That was also by a high court. So it's parallel. So it's parallel to what Judge Ngugi has done. So it's one of those things where it depends on who wants to use it. Then they'll go and fish for the authority that says what they want to say. Where it stands currently, it applies to not just the Samburu governor, it also applies to Honorable Waititu. And because Honorable Waititu's matter now is being handled in a lower court, you would expect that that ruling now would be pulled by the state in support of what they're saying. But you had the argument by Tomojenda for Governor Waititu,
correct,
which is what was fronted for the president that time. You must look at the presumption of innocence. You must look at the process of removing a governor. Now, you would argue that if this matter is successful, then you've got grounds under 181 to remove this governor. But you've not yet gotten there, because unless you have a conviction, you cannot say that they're in contravention of any law in Kenya. However, what Steve Ogolla said in your vox pop there is something that I would actually co-sign. When you're in such an office, there is a very huge element of trust that is given on you to manage the finances of the entire county on their behalf. The standoff we've been having with the Division of Revenue, part of the argument from the members of the National Assembly in slashing some of the money going to counties is that, by the way, you guys, even that which we give you, you're not running it accountably. You're not doing what you're supposed to do. So we must see that there is a problem in county governments, and unless we start holding governors to a higher standard than we already have, maybe we'll not be able to deal with this substantively. So I think the judge is trying to balance interests. She's looking at the law, yes, and that's why she would say, for example, Governor, you cannot go into your office, but if you get clearance from the EACC, you can access your office to do 1, 2, 3, 4. As Chris has said, you can operate from your private office. You can go and open hospitals, and you can go and launch these roads and do whatnot. The stuff that you can still do, but you cannot access the place where the documentation, the people, where you can wield influence to affect the case. Because before a matter is taken to court, it has gone through the rigor of EACC investigating, DCI probably jumping in. It's gone to the desk of the DPP to look at the evidence to see whether there's something credible. So they wouldn't just take you to court on a whim or some. Although this is Kenya, so there's weaponization also of court processes. But you would expect that by the time they're making the decision to charge a governor, they actually have got something
they should have sufficient substantial evidence. Let me come to you, Honorable Kioni. You're in an elective position, and where does that leave us? Does that leave us at the whims or the decision of that particular governor to decide whether they're going to, through their integrity process, say that I'll step aside, or is there a clear law that gives us guidance on how that should be handled?
I think one perhaps to look back again at this judgment of 2012, the one that related to now President Uhuru Kenyatta and his deputy. But I recall the argument was, can they vie? And the issue was, yes, they can vie. Once you have managed to, once you've been elected, because I think the issue was you cannot deny me an opportunity to choose among all these leaders. But the issue is now you have been elected, and there are these charges on your head.
Far before you.
Yes, and I think that is where you look at this provision that we did. And I want to say that I was seated in this parliament. And I want to tell you that chapter 6 of our constitution is so crucial. If we want to fight corruption, if we want to improve the level of governance in our country, it is a chapter that we must look at very critically and also in a way that it helps us achieve what was intended for us to achieve. I think Article 8 calls upon Parliament, one, to enact legislation that would help implement Chapter 6 and also promote its implementation. But this act, this is the Anti-Corruption and Ethics Act, I think so, yes, Anti-Corruption and Economic Crimes Act, Section 62, we passed it during 10th Parliament, and it was very, very controversial and contentious. A section of the cabinet did not want it passed. Another section wanted it passed. At the cabinet level, they disagreed so badly that the issue was again referred to Parliament. This we were able to gather because we were told. Mother Karua was the champion of this act. And what she was saying is that why would you want to treat public officers differently from the state officers? Mm-hmm. And that is where Section 62 says a public officer or a state officer shall, what did I read? A public officer or state officer who is charged with corruption or economic crimes shall be suspended at half pay with effect from the date of the charge until the conclusion of the case. But then we went down at clause 6 and said this section does not apply to state officer. So we provided for all that needed to be provided under Chapter 6 of the Constitution, but then removed the state officers from its application. I think that's the crux of the issue, the matter. Mm-hmm. And while I hear and I agree with the sentiments that are from my colleagues and even those who have come on air, we need to decide as Kenyans that we want to go this. And this is not removal of the governor. Just telling him to step aside, you have your pay, you are still the governor, but you cannot access that office. There is a deputy governor. That is why there is even a provision for how the deputy governor can run the office in the absence of the governor. All the activities of the county government will continue going on. But you cannot continue. You know, the Chapter 6 also says that when you are in that public office, in private and public life, your behavior must be such that it does not demean the stature of that office. You must promote the image, the integrity of the office that you are holding. For us to achieve all those things under the Constitution, can we honestly achieve them? If we go into a county governor's office and see this is a guy you saw being charged with stealing all this amount of money, and then he's the one who's telling you, pay revenue, we want you to do this, and that office has already lost its stature. And what we're also telling the young people in this country is that you can still, for as long as you can manage yourself around issues of bail and board, you will have your full term. I think it is a very big score, a very big win for this country. If what Justice Mumbi Goge did is allowed to. And I hope the other judges would see it from that. And we want to join, we must join. Mm-hmm. And I don't want anybody, there is of course the issue of innocence until proven guilty. But honestly, if we want to move this country to the next level, where we think corruption is something that we should not engage in, or like the way you wake up in the morning and wear clothing, because that is the way I see people behaving when they get into public offices, we need to allow this to hold.
Okay, let me come to you, Honorable Oluoch, on your thoughts on this being double standards, because of course what is being quoted and what was even quoted by Tom Ojienda was arguing that in the case of Governor Waitito, he says that having integrity issues cannot have him barred from holding an elective office. The question here being the elective office, of course, quoting again what happened during the 2013 pre-election period, where Uhuru Kenyatta and the DP were before the ICC. Are those double standards?
There are double standards, and I think where we missed the bus, in my view, is that at Article 78 or 79, thereabouts, it contemplated the putting into place an act of parliament to give effect to Article 73 on leadership and integrity. I wasn't in parliament then. I'm sure my chairman here will confirm this, that the provisions that would actually have breathed life to the constitution as it is contemplated were actually completely diluted. They are completely diluted. And you've seen in respect of many cases that came after that. I sat through a lot of nomination cases, the late Gerald Otieno Kajwang and others, people who came up, I think he had an LSK case or something of the sort. It came before Lenaola, and there are many previous presidencies that came after that. And they say that in respect of elected leaders, you cannot apply this. And if you put this into context, and this is where I have a problem with Justice Zubik, in spirit, she was trying to breathe life to the Article 73, but there are obstacles that need to be taken into account. Section 62 and 3, 62 talks about suspension when charged with economic crimes or corruption. 63 talks about when you are convicted, what happens? And then it says you are suspended, you're on half pay. It goes on and says what needs to be done in respect of state officers or public officers, and members of parliament, governors are all within that particular bracket. But then there is a proviso. This section 62.6 and 63.4 goes ahead and says where there is another procedure. You remember, this is an act of parliament, and it's giving deference. It's deferring to the constitution and says where the constitution otherwise provides how you should be removed. In the case of a governor, you're talking Article 181. You cannot apply this section of suspension. And by the way, the term is suspension, not stepping aside. Stepping aside is really, I think, an oxymoron, a word we use in political circles. The word is suspension. So it says where there is a provision, you cannot proceed there. And I come back again to Article 38. What is the import of this to the right to representation? And I'll give you a practical example. I was in court representing the Honorable Opio Wandai in the last parliament when he was suspended for gross misconduct by the speaker. That provision stated that when you are suspended for gross misconduct, you stay away from office for the entire session. That session, when interpreted, was from the month of March of that particular session to the next year, close to 1 year. And this is what Justice Odunga says, that the people of Ugunja have a right to representation which you cannot take away in a manner.
Because he's an elected member.
He's an elected member, and if you want to keep him from office, and it is almost para material with this, they said that Opio Wandai could not access the presence of parliament, meaning he could not access his constituency office, he could not access other facilities that members of parliament would do in order to effectively oversight, represent and do other things that a member of parliament does. The court said you cannot do that. You cannot withdraw by dint of a standing order the right of a member of parliament to represent and the right of the people of Ugunja to that representation. That's what I find with the ruling of Justice Ngugi. It has to be contextualized and put within the four corners of the constitution. And in the end, I think if we want to give effect to what she was trying to do, we may need to relook the law afresh. Yeah.
All right. So where does that leave us after all the legal mumble jumbo? You know, Kenyans are left wondering, does that mean then the governor should continue working because by virtue of the fact he's an elected member and there are certain jobs or, the mandate of what his office brings to board. But there was also what Honorable Kioni has mentioned, that we do have a deputy governor. So their representation and the work that the governor is supposed to do still continues. So does that mean then we ignore that whole chapter and say that let him continue because he's elected? Joy.
And you've taken the words out of my mouth. I was like, in the context of Honorable Ndai, because he's the only member of parliament, it's a different scenario than what the governor is facing, because of, even in terms of, you've seen death, his deputy is supposed to be able administrator in his place. So it's a little bit of the comparison, but there is a point he has made that I cannot ignore. That there is something, and even I think the LSK, we've had this in our politics. When it comes to somebody being elected, what is the role of this integrity questions and these questions of fitness to hold office, where do we draw the line? And in the LSK, I know we've had that argument of, is it our responsibility to collect taxes for KRA, for example, or to make sure that HELB has collected their loan from you before you can run for office? Are we supposed to do their job for them so that we can allow you to run for office? So it's a little bit of a conundrum. I don't know that I have an answer right now, but the thing that I would like to challenge even the legislators on this table, when we write laws that bind us into little twists and turns, it doesn't help us. I think one of the criticisms I've had of our constitution is that it tried to be grand norm and statute rolled into one. And that is why you have provisions in the constitution that even when parliament tries to cure or to balance, it becomes difficult, or vice versa, because you find there is always somewhere you can declare, this can be declared unconstitutional, but as soon as you do that, you step on this other provision, and then now we find ourselves in a mix. Maybe it's time for us to have a conversation and to have a nuanced conversation and have sort of an agreed practice that this is what we shall be doing when we are faced with this, because it is a reality that there is looting going on in counties. It is a reality that there is looting going on right under the noses of people. When you listen to some of the things, like I've traveled to Maralal for work, and at times you're driving by and you just see this shiny big house set in the middle of the hill, in the middle of nowhere, and then when you ask, you're told, oh, that belongs to this and that politician, this belongs to that MCA, this belongs to that county assembly. So there's some things that show you and tell you maybe there is something going on.
Right. Yeah.
We cannot say, simply because you are elected, we shall not really look into this until when you're out of office, or until you've done something so huge. Because the nature of stealing, I'm not going to steal when the torch and the light is on. I'm going to do it under the cover of darkness. How we uncover this is through court process. Court process can be subverted. Maybe we need to look at a court saying 30 days, maybe not 30 days, but maybe there may be a more efficient way, because I agree, it can become, you've been removed out of office for the rest of your term. That cannot be justice for the accused person. It cannot be justice for the electorate.
Still presumed innocent until proven
we need
guilty.
to have that conversation and say, okay, when it comes to these matters, this is how we will handle them. This is the parameters within which we'll play this game, because we don't even have to be bound by the law. It can become a gentleman's agreement amongst our leaders.
Okay. And let me come to you, Honorable Kioni,
wrong.
and the question here being, where does that leave us as a country on the question of accountability? Does it leave it on the desk of that governor or that elected member of parliament or that elected member to make that decision and that call that will stand and say, and in this country we've had people stand up and say, I am completely innocent, under my dead body, I'll never leave that office. Then they left the next day or days after. So where does that leave us? As Kenyans, we are left thinking the justice system should be there to take care of us, but evidently there are twists and turns that can be used. And again, like I've mentioned, we have quite a number of politicians who are lawyers, so they know where the corners are.
And the lawyers are also there when we are making the law. And they will make it in such a manner that it becomes difficult perhaps for the judges to just decide quickly what we intended to achieve. And this is exactly what happened during 10th Parliament. And I'm trying to bring out the issue that this is a statute that was trying to say you have a public officer and a state officer. Something that I don't want to bring that debate here, but something that you see the SRC trying to do. Classifying some people like state officers and others differently. But I think there is some finer difference that we can bring out here. The governor, though elected by the people of that county, has been elected to not to represent them, but what to do, to undertake, to administer funds and make decisions. He is not walking into an assembly like the MCAs or the others to represent them there. It is an executive function that he has been elected to do. While you look at a member of parliament like the one who was being represented by Mheshimiwa Roach, is representing people, and there isn't a quick way of getting an alternative voice on behalf of the people of that constituency. And I think that may just be the difference between those two elective offices. And I believe that In my mind, I see that the governors cannot get it, they can't get it their way. And again, you cannot leave it on their desk for them to decide what to do. This country, we know what to do. We actually declare and swear in front of everybody, I would rather die, and we haven't seen anybody dying. So we cannot leave it, we cannot leave it to the elected people holding these offices to decide, because we already know what they are going to say.
Okay, does that then usher and open the door for what Joy is calling a conversation in form of a referendum? Is that what we need to do?
On this particular one, I want to say that in my mind, I think we need to read these provisions of Article 73. Mheshimiwa Rush has mentioned them, 73, 74, 75, all the way, and ask ourselves, how are we living up to those? One is that when you are holding that office, you are supposed to demonstrate respect for the people. You're supposed to bring honor to the nation and dignity to the office. You're supposed to promote public confidence in the integrity of the office. How are you doing these things when you're already facing a charge this other side? Fine, innocent until proven guilty. But what are we doing to these provisions in the Constitution? And I think that is why Article 8 then calls upon Parliament, and this act that I'm talking about is the one that was done by Parliament to try and actualize or operationalize these provisions. And it says, Parliament shall enact legislation making any other provisions necessary for ensuring the promotion of principles of leadership and integrity referred to in this chapter and the enforcement of this chapter. That is what that act was supposed to do. And you can actually see that it was actually achieved by we actually achieved it by and large, other than for those provisos that Mheshimiwa was bringing, and they were trying to just remove the elected offices. And I want to say, in a selfish manner, and I'm trying to say in many words, that parliament was very different from the parliament that we have today. That parliament was made up of very many Kenyans who had served in previous other positions in government, and also members of the cabinet. Today, we have younger people in parliament, people who have not even had an opportunity to be employed by the public service, people who don't have skeletons in their closets, and they have nothing to fear. These are provisions that we should easily delete to allow the courts to fight corruption in a better way.
Does it usher and open a door for us to have a referendum? Is that some of the things that maybe we're trying to fix when we talk about a referendum? And of course, there's the question of which referendum are we talking about, or which is the question. But is that an avenue that maybe Kenya needs to explore?
We need to look at what Article 255 and 256 or 257 say. Not all amendments to the Constitution need to go to the referendum. They will go to the referendum if they touch on the independent offices, in the structure of devolved governments, the tenure of office of the president. We need to look what actually does it say, because you can amend the Constitution under 256 to parliamentary procedure. So if we look at the ethics, and Article 73, and see that there is a provision that needs to be changed, of course we have to look at the other articles I've referred to, Article 38, the right to representation. Maybe if the right to representation then can be qualified, and then Article 81 on procedure for removal, so that the position of governor, like my chairman has said here, is more executive than representative. We can make those exclusive provisos. But I do not think myself necessarily that in respect of this question, we would need to go to a referendum. These are things that we can amend in Parliament.
Okay, and maybe even on the question of referendum, as we wind up, Joy, we have quite a number of proposals before Kenyans. Of course, we're waiting for BBI to give us what their conclusion of what they have collected or what they have gathered from public participation. But we do have the Okuro Court, proposal and bill that he has put forward. And your thoughts maybe on that as a way forward for Kenya?
In the wisdom of the people who drafted the Constitution, they did something that I think was pretty commendable. They said that the sovereignty of the Kenyan people, the power vests in the Kenyan people, and they can exercise this power either directly or through their elected representatives. So for most part, we are aware how we exercise our power through our elected representatives. But when it comes to exercising our power directly, now they gave us Article 257 that says, you know what, if you are not happy with what your elected representatives are doing, you can have a popular initiative where Kenyans themselves make their voice heard by force. And in my opinion, that's what a Kuru court decided to do. So he's paid the price to collect the signatures for the voters. He has paid the price to have the matter draft a bill that was accepted by the IEBC. Now he's going around in the counties trying to convince at least half of the counties to buy into this agenda. If he's successful, because part of the questions that he's proposing in his draft bill touch on the exclusions in Article 255, then it means the matter must go to a referendum. I've heard some people arguing that, oh, we are going to kill this thing in Parliament if one house agrees, if another house doesn't agree. And I look at them like, there's a reason it was called popular initiative. Because this is where we bypass Parliament, our National Assembly and the Senate. They can argue, they can debate it because it will be sent to them. They can debate it and do whatnot. But this is an opportunity for Kenyans to be heard directly. With BBI, my fear with BBI is we have seen excellent recommendations coming out of the Ndongo report, the Kriegler report, the TGRC report. All these people have their fact-finding missions. They write excellent reports. They make brilliant recommendations. The Waki, Bahashaya, Ocampo, we've had proposals that seemed watertight, but at the end of the day, they fall at the last hurdle. So if BBI manages to crystallize and become a referendum eventually, so be it. But right now, the train that is already in the station, that has pulled the whistle and is ready to leave, is Punguza Mzigo, because they have bypassed what would ordinarily be obstacles in this way. Okay. I must give it to them because they did it almost under the cover of darkness. All of us are like, hey, yeah, they've already reached here. But quite frankly, even if they do not succeed in getting to referendum, or if the referendum fails, they have opened Kenyans to the fact that, you know what, we are not held hostage by our politicians. We actually have an option if we pull together.
Okay. Honorable Kioni, your closing remarks and also just your thoughts on the referendum, and possibly if that's what Kenyans need, if that's a silver bullet that Kenyans are waiting for to sort out so many things that we have issues with.
One is that I look at the court bill, and it's a good thing because Kenyans now know that they can actually amend the constitution if they so desire. But I think it is something that needs to be very, very carefully thought through. And the anger of Kenyans and perhaps sections of Kenyans towards members of parliament, towards those they have elected, should never be used or should never be a reason as to why you start an amendment to a constitution without thinking it through. And I hear Kenyans, I can tell you there are also areas in the constitution that I want amended. But in the process of amending this constitution, we can easily lose a lot of things that we have already gained as a country, and things that are very, very difficult to secure again in the constitution, and things that can actually get us into some very serious conflicts between the communities. And I want to tell you one, if you touch on representation of the people, if you did not sit through perhaps the final stages of the constitution making like I did, you would not understand how lucky we were as a country to narrate the way we did and still have a peaceful one country. If, just to pick on that one aspect, if you were to say that you are reducing the number of constituencies from 300 to 150, it means that you are halving, reducing by half. It may make sense when you put the mathematics on the table and start saying the salaries and what and the rest on the table. And Kenyans will say, yes, a lot of money is being paid to MPs, the senators and the rest. But wait until you tell the people of Lamu, from today going forward, you will not be electing your member of parliament. Come to the people of Darago and tell them, from today onwards, the whole of the county of Nyandarua will be cut into 2 constituencies. You will not get an answer no, but a conflict. People will say, if it has anything to do with my constituency, my county, we will fight for it. It is such a dear thing to Kenyans that it should not be taken so lightly. We can talk about it, but I fear what this thing is all about. Again, when you say that you want to take the CDF to the MCAs, I think there is another issue that needs to come out. One is that the CDF is not even part of our 2010 constitution. The courts have said in many words that if we have the kind of government that we have today, a presidential kind of government, you cannot have CDF being managed by parliament, being managed by members of parliament. Members of parliament are there, yes, we make decisions, but legally you cannot again provide for it in the constitution, because it cannot run with the kind of government that. So there are quite a bit of things, very useful. Our court has helped us, but there are many things that we can bring out. I don't want to look like I'm fighting it at this point. Yeah. But again, it's left station. This has nothing to do with our court. He can move around the counties campaigning, but it completely left him. We cannot amend it. It will come to parliament, right. And I am not sure. Allow me to just say this.
Yes, I need you to wind up.
Yes, let me say this. When we say that it is a law that requires deeper thoughts, as members of parliament, it's not that we are opposing. So that people don't just go to the other side because members of parliament are saying it's not a good law. This law can hurt this country going forward, and we don't want to get
Honorable Loch, I'll give you the last comments and your closing remarks.
Yes, I just wanted to say, as I close, that the path that Okot and Third Way Alliance chose in Article 257, you can choose to do amendment to the Constitution by popular initiative in 2 ways, by way of a general suggestion or by way of a draft bill. He chose the way of a draft bill, which poses very many difficulties because it's not capable of being amended. If he had chosen general suggestions, then people can play into it and say, this is a good idea, but the implementation of it, however, let's do this. Right. 2/3 is a good idea to achieve, however, let's tweak it this way. Punguza mzigo and the number of MPs is good, but then again, making 2 people to be representatives in a county is not practical. The other last thing here, issue about it, as I try to just punch one hole into it, a senator who will be elevated to be the upper house runs and looks for votes in the same county that a member of parliament will also get, and perhaps a member of parliament will end up garnering even more votes. But then the senator ends up being a member of the upper house and has veto power over the member of the National Assembly. It's not practical.
All right, thank you, gentlemen. We'll have to wind, lady and gentlemen, we'll have to wind it up right there. That's Joy Brenda Mdivo, who's a lawyer, Honorable Jeremiah Kioni, Member of Parliament, Daragwa, and Honorable Anthony Loch, Member of Parliament, Mathare. That's a political point. We take a break, but do stay with us.